Hey y'all, what is good? I have missed everybody so much. God, I haven't had the energy nor the time to make any content, and I apologize, okay? But I'm here now, so don't hold it against me or whatever. I do want to thank the 624 subscribers that we have. I do appreciate everybody subscribing, liking, engaging, all of the good stuff. Okay. Even though I haven't been able to produce anything in about 2 weeks. So thank y'all from the bottom of my heart. So as you see by the title, we are going to be doing some Darrell Brooks content. Now I know that I said I was not going to do it anymore. I know. But I've had some time off. I had some time to, gather myself, gather my thoughts or whatever. And so, hey, we're going to do one. I'm not doing one every day, but, we're gonna do one today, and in a couple of days I'll do another one, and in between there, I'm gonna do some videos that I want to do. So I realize that the bulk of you really enjoy my Darrell Brooks content, and so I'll do some here and there for y'all, and then I'll do the other stuff for myself, and for other people that want to learn about other cases. So I ain't gonna tell y'all what to do, and y'all ain't gonna tell me what to do. Okay, because don't nobody tell me what to do. I got almost grown kids. I don't tell nobody else what to do. Ain't nobody gonna tell me what to do. Okay. So today, Mr. Darrell Brooks is going to face his accuser by way of Detective J. Carpenter, right? So, as you know, Darrell thought that he had a friend in Darrell Carpenter. He thought since they fellowshiped together, they talked about the goodness of the Lord, and Darrell was able to explained to Detective Carpenter how hard it was out here for a pimp. He thought they had something going on, all right, until Detective Carpenter started pressing him for information. And Darrell said, you got me effed up. I ain't doing none of that. All right, handcuff me, take me to the jail. My life is over. And so today we're going to watch Detective Carpenter be cross examined, if you will, cross examined by the one and only Darrell Brooks, aka third party intervener. All right, so let's share this screen and jump over to the YouTube streets and see what is going on over there. All right, give me 1 second.
There's no bets.
You referred to interrogation starting.
Hold on. Okay, hold on, y'all. Hold on.
At a specific place. I'm referring to the substation. Is it fair to say that there was no interrogation that took place at the substation?
Yes,
Yes, that's fair to say.
there was no interrogation at the substation in Waukesha.
Do you recall what information was obtained at the substation?
Yes,
Do you recall what that was?
yes,
Can you state for the jury and for the record what information you obtained at the substation?
yes, sir. Basic biographical information. So I obtained your first name, Darrell Brooks. Your last name being Brooks. Your full middle initial, or full middle name, I should say, being Edward. I learned that you were a junior. The date of birth, February 21st, 1982. Additional information obtained was your home address, which was 40, you provided as 4014 North 19th Street in the city of Milwaukee. Phone number, your emergency contact, which you provided as Dawn Woods, whether you were employed, going to school. I remember talking with you about your tattoos and other physical marks that might be on your body, your hair color, eye color, photographs were taken, um, things of that nature.
Kept mentioning that name, pretty slick.
Sure, disregard that last statement, sir. Please ask questions. You'll have an opportunity to
Uh,
testify later.
oh, I got a lot of questions.
Now, one thing that I do want to point out is that when Detective Carpenter was being um, on his being questioned by the state or what have you, Darrell Brooks did constantly interject with his obnoxious objections. However, if we go back and watch that footage, you can see that he was very engaged in his paperwork. He didn't give Detective Carpenter any type of eye contact. In fact, he didn't look his direction whatsoever. However, I did see him taking copious amounts of notes. He was fully engaged with all of the paperwork that he had pertaining to the interview that took place at the hospital and the substation, as well as the interrogation. Um, and so the way I took that was that he was just very, very, very upset with Detective Carpenter. And this particular cross examination was more so pertaining to the interrogation and how upset Darrell was that he felt Detective Carpenter. He felt, sorry, he felt that Detective Carpenter wasn't forthright with information that he had, and so he basically was just lashing out about that. It had nothing to do with the case itself. It was more so of him basically trying to aggravate and make Detective Carpenter out to be a liar, okay? Because, Darrell felt like he was withholding information and not being truthful, okay? Because that's just the way Darrell thinks. So let's move on.
And at that point in the investigation, what did you initially know?
At that point, we knew that the red Ford Escape had driven through the parade route and that you'd been identified as a suspect.
And why was that information not provided at that time to the detainee?
The information at the time wasn't presented to you, Mr. Brooks, because, as I stated in my earlier testimony, it was still very fluid. It was very chaotic out at the scene. There was still a lot more that needed to be learned.
So is that standard procedure to not tell a person why they're being detained?
Well, we didn't not tell you. That's incorrect, and it's misleading to the court. You were informed you were being detained for prowling, loitering, disorderly conduct of that nature.
Is
I
that the
just didn't
same
bring.
as
Can I finish, please?
Oh,
I just didn't bring out the parade part of it.
why not?
As I stated in earlier testimony, it was very fluid.
now, see, that's a question that I had, and I know a lot of people were really going hard on me about my interpretation of the interrogation. And I had stated at that time that I believe that Detective Carpenter should have told him up front what was going on. And I understand that, in the beginning, you have to get that biographical information, you have to build rapport, with the detainee, which I felt like he did some of that while he was in the hospital. However, once they met him again in the room, it had already been well established that Darrell was a liar. They knew what had taken place um, the night before. They knew that people died. In fact, 5 people died the night before. They were able to positively identify Darrell. And so, in my opinion, even though it would not have made Darrell tell the truth or offer up any type of additional information, still to speed up the process, them letting him know why he was there, what he did, it wouldn't have hurt anything. And I know a lot of people were like, "No, he had to prolong the interrogation so that the jury can see what type of person he is." It didn't matter. The jury can't play off of emotion anyway. They have to go off of on the facts, right? So they have to take the evidence and make a decision. So it didn't matter if they interrogated him for 5 minutes, 5 hours, 3 days, it didn't matter. The facts are the facts and they speak for themselves. No matter how long or how short the interrogation was, no matter how much Darrell manipulated them, no matter how much he lied, the facts are still there. And so, in my honest opinion, based off of what I saw in the interrogation, it would not have hurt if they would have given him information at the jump and not let him continue to blame someone that had nothing to do with it. But that's just my opinion.
Fluid and chaotic, and a lot of information wasn't yet known. So I was waiting to receive more information.
Did you state in your early testimony if that was standard procedure or not?
to
it's
be
standard.
laughing. I'm sorry to be laughing. Y'all, why is he bucking his eyes like that? He is so pissed at Detective Carpenter. He does not know what to do. Okay. He is so pissed at him. He has to figure out if Detective Carpenter broke the damn rules. Now you done set up here and plow through this dang on parade. Ain't shown a bit of remorse, none whatsoever. But Detective Carpenter is the one on trial because he didn't tell you up front what was going on, even though you witnessed it firsthand. Dude, like I
Standard.
So with every detainee that you've ever detained during your career, 18 years, right?
Yes.
It's standard procedure to not tell someone being detained what they're detained for.
As I had stated in my earlier testimony, Mr. Brooks, I explained to you were detained for prowling and loitering and disorderly conduct. Based on the lack of information
and y'all know I gotta keep interrupting because this is not my video and this is a commentary channel. So if you don't like that, please head over to Court TV where you can watch this in its entirety. Okay. So, I wanted to go over again what it is to be detained and arrested. If at any point in your life where you get arrested or you are pulled over by the police and they detain you, that is not arrest. So, initially, he was detained because they had to get more information, and so that's what he's asking him about. So, they detained him to see if they had enough probable cause to take it to the, I'm saying Ohio, that's where I'm from, to the, prosecution to see if they can get a warrant to arrest him. And so that was the initial questioning. He keeps confusing being detained and being arrested. When you're arrested, they have probable cause to arrest you, and then you are formally charged at first appearance. And so, no, right away, they don't have to tell you anything. They're gathering information. So the main purpose is to question you to see what type of evidence that they have. And they detained him to question him, but not only that, to keep an ear to the street and with the other detective and investigators to see what information they had to go back and question him again, but while under arrest to see what information they get. Can they get motive? Can they get a reason why? Any of that. And then they will make the formal arrest and charge him. So he's intertwining the two. So Detective Carpenter, at the point of being detained, does not owe him anything.
information on the parade that was not brought up. So what I can clarify for the court at this point is that in situations where so limited information exists early on, it is standard not to convey that information to suspects.
And what do you mean by it's standard?
I mean that I don't tell them because I don't have all the facts yet, and I'm not looking to necessarily accuse them before I know the nature of what they did or didn't do exactly pertaining to that incident.
So it'd be fair to say that it was not a fact as far as the information you learned at to that point in the investigation.
Objection made.
Grounds.
Sustained is to the form of the question.
So at that point in the investigation, it wasn't a fact.
Objection, same question.
Grounds.
Sustained is to the form of the question.
At that point in the investigation, the information you had at that time, you weren't sure about.
I guess which part?
All the information that you had up until that point.
Okay, about the prowling or parade, I don't understand which part of it you're talking about.
All the information that you've obtained at that point in the investigation, you weren't sure about. As you just said, you don't try to assume.
But that's the point of detaining somebody. So he was detained based off the fact that several people had called in that he was walking the streets, no shoes, no coat. He had asked several people to use the phone. He was knocking on doors. He was ultimately trying to trespass by going into that one building to get warm. So initially, um, there were calls about that, so that was the initial concern. Furthermore, they had video evidence of him actually driving through the parade. However, that was not enough at the time to arrest him So that's why you were being detained. So no, he did not have all of the facts. When you're detained, they don't have all of the facts. They have enough to question you until they gain probable cause. Probable cause means they have enough evidence to charge you with a crime based on either surveillance, eyewitness testimony, um, things of that nature, Darrell. God, you saying it 3 or 4 times ain't gonna make it make sense.
Guilt or anything like that until you have all the facts. So at that time, at that point in the investigation, is it fair to say that the information that you had obtained so far, you were not sure about?
I wasn't sure if you were the driver initially, but it was believed you were involved.
And you knew that to be fact?
Yes.
Yes, the information being provided was that you were involved.
So it'd be fair to say you knew that as a fact.
Well, hold on. I'm gonna not allow him to answer that. This jury will determine the facts of this case. If you want to ask him his opinion, you do that at your discretion.
He said fact. He said facts.
You asked the question, sir. So
But he brought it up first.
I'm going to strike the question from the record. And Mr. Brooks, you're directed to rephrase.
I will rephrase, but I do not consent to being called that name for the record.
Nobody
Noted
cares.
and overruled.
You stated that there were some loitering and prowling allegations. Why, to your knowledge, were those ever charged?
Charge the relevance.
Grounds.
Overruled. The witness may answer.
No,
And do you recall why not?
Detectives aren't the people who charge detainees or inmates with anything. That is left up to the prosecution. So he would not be the one to say, "Oh, well, we saw you walking around with no purpose. We're going to charge you with this." No, they take the evidence that they've gathered and they take it to the prosecution. The prosecution will then use that evidence, match it up with the statutes available in that specific state, and see what applies. Then, when you go to first appearance, your charges are then presented to you. You may or may not receive bail. They let you know what your constitutional rights are. They determine if you are indigent or not and if you will qualify for a public defender. Detective Carpenter isn't the one to decide what your charges will be. Furthermore, the loitering charge really compared to what you compared to what you're up against really doesn't even matter, Darrell. Okay? You're just throwing anything and seeing what'll stick at this point. Let's just come on. Come on.
no.
Also, I'm gonna stop again and say that I think Detective Carpenter was the closest thing that he got. He and Detective Casey were the closest that he got of being able to question the state without questioning the state, if that makes sense. He knew he couldn't call the state, the prosecution to the stand. And so I feel like since both of them being detectives and both of them being connected as closely as they were to the case, I think that is why he went so hard on the 2 of them, um, because he wasn't allowed to question the state, but that's just my thought. What y'all think?
So why did you constantly tell the detainee that they were being detained for loitering and prowling if you in fact knew that there was another reason why they were being detained?
Objection asked and
Grounds.
answered.
Sustained. That's the form of the question and assumes facts not in evidence.
What was the significance of the FBI being present?
The significance of the FBI presence was the early on concern that this was a terrorist style event.
And you said that this was the terrorist element. And what is the this? Can you explain what the this is?
When you drove your vehicle through the parade and struck people.
Which at the
Checkmate.
time you stated you did not know is fact, correct?
That was still being investigated, yes, but I know that's what occurred now.
Now versus then.
Initially, it was unknown if you drove.
That's what I was
stated.
That was the question.
But the investigation showed that you were the driver of the vehicle.
I really want to understand what Darrell's perception of time is. So, if anybody, whenever somebody commits something and it's a mass casualty, shooting, um, I don't know, a mass poisoning or some sort, it's going to be considered a T attack. I can't say the entire word, right? And so they're going to call in the big boys, the alphabet boys, to come and investigate because they have specialized training that a county detective will not have. And so they have to come in, and I'm sure y'all all know this, but I got to give commentary. So just go with it. They have to come in to cross off boxes. Okay. Was this a T attack? How many people were involved? What else was going on? Are there any BOMBSs involved? Are there still people on the loose? Was this a ring? Was this a thought out, plan? What all is taking place here? Is it just one person? They have to investigate all of that. Then they will turn their findings over to the police, and then the police will go from there. So it's not uncommon, it's not unusual for the FBI to come in and intervene and do their part of the investigation prior to handing off to those under them. You drove your car through a parade. That's not something common. It's not like you just hit a pedestrian while crossing the street. You purposely drove your car. So, yes, the FBI is going to be there to make sure that this type of attack is not a T attack or that there are other people involved.
And initially you didn't provide that information, correct?
Correct.
So do you know if the FBI continued their part of the investigation?
Eventually, the investigation was strictly run by our department.
And do you recall why that decision was made?
My understanding is there wasn't a terrorism link.
I'm sure throughout your career, you've done lots of interrogations. Are there usually multiple officers that do the interrogation or usually just one?
It can depend on the circumstance. It's not always more than one, but it can be.
And what would you estimate would be the normal procedure for interrogation as far as law enforcement wise?
I really can't speak to that. I think every department probably has their own potential way of doing things.
Up until that point in your career, when you interrogated the detainee, had you ever conducted an interrogation with FBI present?
Not prior to that date, no.
You made reference to car key being found. Do you recall that?
Yes, I do.
Did you yourself find the car key?
No, I did not.
Were you told by other law enforcement?
I guess told what exactly?
That a car key was found?
I was not specifically. Your items that were located on you during the search were turned over to Detective Stern, and the car key was one of those items.
And to the best of your knowledge, you didn't have that information at the time, correct?
At which time?
At the time that the detainee was detained in the substation.
Thank you for that clarification. Go ahead and
You're
answer.
I just want to make sure I guess that I understand. So you're asking me what I knew about the key, or if I knew where it was found at the substation? I don't understand. Can you clarify that, sir?
I guess the clarity that you may be looking for is what was found and brought into the substation.
Okay. The Ford ignition key and other items that I alluded to in my earlier testimony include your photo ID and credit cards with your name, or debit card, credit and or debit cards with your name on them.
That you did not search and find yourself, right?
That's correct.
Did you conduct any searches?
I don't recall if I did or not of your person.
So it'd be fair to say you don't know where certain items were found at the time that you learned of there being items found, correct?
No.
No, as in?
No, I knew those items were found on you in the search. Maybe not the specific pocket, but I knew the officers found those items in your possession.
Were you at the scene of the search?
No.
So how do you know where they were found?
Because they were turned over to Detective Stern as your property.
Not to mention the fact that the other Detective Carpenter, or Officer Carpenter, I'm sorry, had body cam video of the entire arrest. Darrell, did you forget? When they pulled that good old sandwich out of your pocket, your ID, Erica's government assistance card, the key, sir. What are we getting at here? Like, it doesn't matter how he got it. He got it. It's yours. What are we alluding to at this point?
How do you know where they were found, though, if you weren't at the scene?
Because I was aware officers searched you, and it's not reasonable to believe they were randomly in the grass at the house you were at in a city that you've indicated you're not familiar with.
Exactly.
Can you strike that last answer from the
No.
record? I didn't
Mm-mm.
refer to any house, grass.
You asked
City.
an open-ended question. His answer will stand. Your request is denied.
So it'd be fair to say that in the question, I did not mention a house, grass, or a city. That'd be fair to say.
You didn't mention it, but I know you were found at a house in the city of Waukesha. And I know you're not familiar with Waukesha because that's what you told me when I interviewed you.
Can you strike that last
No,
answer?
we cannot.
Request is denied.
On what grounds, Your Honor?
You asked the question. He answered it. If you want to limit, ask leading questions and direct him.
That is, you're right.
You
During
made
cross.
you made reference to the house where the detainee was found, the grass, the city. Could it be possible that that's where they were found? The items that you are referring to?
No.
Even though it'd be fair to say that you were not present.
Correct.
Why would your belongings just be in a random location? And even if they were in a random location, they still belong to you. I'm just not.
You made a lot of reference to the the body pain and having to be checked at the hospital and being medically cleared. Would that be fair to say?
Yes, we took you to the hospital for clearance.
Are you yourself a doctor or have any training in the medical field?
No, sir.
So it'd be fair to say that you cannot know how a person's body is feeling. That'd be fair to say?
I can't explain exactly what another's body's feeling. Correct.
So it'd also be fair to say that there's a possibility that you can be incorrect about assumptions made to pain reference. That'd be fair to say?
Pain is subjective. You lied about being body slammed, and we all know why. All right. You lied. There is no documentation that you reported any symptoms of pain on a pain scale at any time other than when people were around you, if that makes sense. So the only time that you showed that you were in a great deal of pain was when you were in an uncomfortable position and you wanted sympathy. So, yes, we made observations that at certain points you were able to fully extend, flex, and circumduct your shoulder without any pain. And then, when the pressure was placed upon you to answer certain questions, sir, that is when all of a sudden you can't even move. The pain hurts so bad you want to cry. So, yes, we can make assumptions about you lying about your raggedy shoulder. Okay.
Say?
I think that depends on the circumstance. In this specific circumstance, you
Answer
told
the
me.
question, the last follow-up if he wants it.
Okay.
Next question.
You made a reference on one of the exhibits. I'm not sure exactly which one it was. It was the first interrogation in the police holding room in the hospital. In that exhibit, you made reference to the FBI being present because you were short staffed. Do you recall that?
I don't recall exactly what I said, but I recall acknowledging their presence. Yes.
And you made a reference to short staff. Can you explain what does short staff mean?
I don't recall if I said that or not.
Now, if my memory serves me correctly, which I know at times I do forget, and y'all quick to check me on that, so hey, it is what it is. I do recall them saying that they were there to help out, and they were short-staffed. I'm pretty sure I remember them saying that. However, we all know that the police can lie to you for, the sake of getting information. So it really doesn't matter if they were short-staffed or not. By law, they are protected and they are allowed to lie to get information from you. So it don't matter.
I don't know if it's Exhibit 172 I'm referring to. Or can you pull up Exhibit 172, please?
You referring to the photo of the identifiers and the items found?
Is that
That's
172?
172, yes.
Or I don't think, is it 81 then I'm referring to?
81 is the audio recording.
Okay, it's
I'm sorry,
81
81 is the video and audio.
of the,
Is it just the audio? I was right the first time. It's
okay, I think it's 81.
You would like the audio recording from the hospital.
Yes, Your Honor.
Is there a part you'd like to direct the state to when they pull it up?
Because it's the audio, I'm assuming it'd be probably as soon as the defendant is brought into the room.
It was played starting at 4 minutes and 25 seconds through 14 minutes and 25 seconds. Do you want it started right at 4:25?
Yes, Your Honor.
Okay. The state would please assist with that.
Oh, he's so polite, isn't he? Yes, Your Honor.
Do you know how long you want it played, or do you want the whole thing? The
I don't-
same clip?
I don't need the whole thing played. From what I recall, the point that I will refer to is pretty early in that.
Well, how about we start at 4:25 and then you say pause, please, when you want it to be paused by the state.
Okay.
All right, go ahead.
I'll go grab you. I'll tell you.
Darrell?
Yes, sir.
Hey, Darrell. I'm Jeremy Wojcicki, the FBI. FBI, yeah.
FBI.
I'm Mary. Yep.
They're just kind of helping out because we're so short-staffed tonight. So,
Thank you.
Okay, he
It's
was.
paused at 4 minutes and 56 seconds. Go ahead.
From hearing the audio on this Exhibit 81, do you recall saying that the FBI was present because you were short-staffed?
that is my voice. I don't recall saying it in the moment, but that's my voice.
That is your voice.
That is me talking.
So from your recollection, do you recall being short-staffed at that time?
Yes.
And can you explain what the short staff mean as far as at that time, what would short staff mean?
That we were just very short on resources with what happened down at the parade route and the mass casualties and the amount of officers it took to secure that location. We were very short on people.
Now, keep in mind that there were so many people who were in need of assistance medically, that a lot of the officers who were at the parade and who had reported to off-duty police officers who reported to the parade to be of assistance had to assist the EMS drivers with transporting those injured to the hospital. And so that's why they were short staffed. Now, I don't believe that the FBI was there because they were short staffed. Again, I think it was just something that they told him to pacify him at the time. But ultimately, they were short staff of officers, but it didn't matter because the person that would be in charge of the interrogation was available along with Detective Stern. So it didn't matter. They didn't need additional officers to question Darrell. Okay, so again, I think it was just them, the alphabet boys there to do their job, and they just told him something to calm his nerves to in hopes that he would be forthright with information, and you see where it got us. So
And
People were called in off duty.
you made reference to the short staff being the reason why the FBI was present.
Yes.
you know what? I just thought about something. That's not really a bad question if you think about it. Because even if, well, from Darrell's point of view, he had no idea that officers were transporting individuals to the hospital. And so I guess in his mind, he's wondering why, if the police is short staffed, at what point do you say, oh, well, we're going to call the alphabet boys to come in and help us? Why wouldn't you just call officers from another jurisdiction, which is usually what happens? Like, I know there was a case here that I'm going to do a video on in the future, but there were two homeless people who were traveling from downtown Cleveland, and an officer thought that the couple had fired a weapon, but it wasn't a weapon. Their muffler, um, I can't backfired or whatever it's called. And anyway, a police chase ensued, and they had cop cars from about 5 different cities to chase this one car. And so I guess the point that I'm making is that what Darrell's getting to is that if you guys were short-staffed, why wouldn't you just call the next city over or the next jurisdiction to see if they have available officers to come in and assist? Why would you call the FBI to come in and assist? So I'm wondering, is that a question that his previous attorneys had written down in hopes of using against Detective Carpenter, or is it something that Darrell came up with on his own? Regardless, it's not a bad question when you think about it, but that's my opinion.
Is FBI usually present in the situation of short staffing?
No.
Maybe put that off,
Oh,
or do you
yes.
need
I'm,
it?
I'm sorry. Your Honor.
No, it's okay. I just want to make sure if you needed it, it's up. All right, it's
Sometimes
taken
I
down.
forget it's still up there.
Next to us.
Yeah. And you made reference to recording the interrogation on your phone, correct?
Yes.
And why would you use your phone to record an interrogation, especially one of this magnitude?
Because the camera in the room didn't have audio capability.
And were you informed of that? Or let me back up. When were you informed that the camera that was in the room did not have audio?
I don't recall exactly. Prior to the interrogation.
And who were you told by?
Hospital security.
Was that the first time you had ever used that police holding room in that hospital?
No.
So it would be fair to assume that you were aware that that room had cameras.
Yes, I knew it had cameras.
And have you ever conducted an interrogation in that room before that evening?
Interrogation, no, but I'd use the room for other purposes.
So what prompted an interrogation in that room that specific evening?
Well, as I explained in my earlier testimony, the situation down in the downtown area of Waukesha, where the mass casualty incident had occurred, was very fluid. It was still unfolding at that time. We were learning more and more and more about what occurred. We decided to start the interview at that location to see if he'd be willing to shed light on for us as to what you did or did not know. And again, I'll go back to statements I made earlier. There's a risk inherent with every transport. I didn't know where your ultimate final location was going to be that night. So to
Mhm.
now start bouncing you from facility to facility to facility unnecessarily was just something we made the decision not to do.
Now, I had said in that video that I did where I played the interview in the hospital that I thought ultimately Darrell thought that he could feign his injury and just keep saying that his shoulder was hurt, something was wrong, they had to do something in hopes that he could be discharged home. Now, it is unclear, or maybe I just haven't seen it because I don't have all of the documents pertaining to this case or any of the jail records. So I am unsure what hospital he was at, but I do know a lot of the victims were taken to the hospital that his mom worked at. So I don't know if he was at the hospital where she worked at or how that went, but I do truly believe that he thought there was a possibility that he could get discharged home. And so the detectives had to be quick on their feet and start interviewing him in hopes of getting probable cause. And so the whole purpose of that interview in that hospital room was to make sure that their information matched up. So, that biographical information along with the camera footage that they had from eyewitnesses as well as the aerial view of the accident on top of the fact that his mom called the police and gave his full name and date of birth, and a description of the car. So with that information, he was able to go back, compare notes with other law enforcement officials, and so he would be taken to the jail and detained until they can formally arrest him. So this is quick thinking on the behalf of the police. I see what Darrell's getting at, but it's not going to work. So they did everything by the book. Okay, so just kill that noise, Darrell. Kill it. Kill that noise.
And at some point, the detainee was moved to the Muskego Police Department, correct?
Yes, you were moved to the Muskego Police Department later in the
And,
evening.
and when did you learn that that would be a location that the detainee would be going to?
We made the decision to try to use that location um, after the first interrogation attempt.
I'm sorry that I didn't hear the last part.
I'm sorry, after the first interrogation attempt.
First interrogation attempt. How would you define attempt?
Well, when we were at Waukesha Memorial Hospital that night in the police holding room that we've discussed, I read you your Miranda rights verbatim from the Waukesha Police Department Miranda statement form. And at that time, you indicated you didn't wish to speak with me.
So it would be fair to say that the Fifth Amendment right was exercised at that point
Right to silence.
under the Fifth Amendment.
Yeah.
So acknowledging now the fact that the Fifth Amendment right was invoked not to speak, or as you say, the right to silence, why did you continue to record on your phone?
So we are trained at our police department when you do an interrogation, the recording is to be left on pretty much until you try to effect transport. So typically what we would do is if our building hadn't been under construction, and when we'd been able to get you back to our police department, where in that situation, we may very well have transported you just because we would have had a municipal lockup there and we could have held you for the night. But that again was difficult based on the fact that we didn't have that possibility at the time. So if someone's in an interview room and at our police department, we'll leave that, even after the interrogation's over, we'll leave that video running until we come back and remove the individual from that room.
Now, I will say that that was a question that his previous attorneys wrote down in the discovery or the questioning for this particular witness, there was a preliminary hearing um, in which his previous attorneys have filed a motion to suppress the audio recording in the hospital, mainly because they said that Darrell asked to cut the interview and that the detectives did not follow suit. But it didn't go quite that way. They asked him if he wanted to talk. Originally, he said he just needed a little bit of information, just a little bit, all right? And they gave him a little bit. And then when they told him that and they asked him again, "Are you willing to talk with us?" He said, "Not right now." They did not ask him any more questions. Darrell continued to ask questions. Detective Carpenter left the room. Detective Stern was still in the room, and he asked questions to Detective Stern and went on to tell his side of the story about how he wasn't drunk, he wasn't on drugs, he smoked a little Mary Jane, he was just trying to get a ride back home, his Cash App card, all of that, how he wanted to talk to his daughters and everything of that nature. So he took it upon himself to continue the conversation. But at no point did any there was no point where they asked any questions related to the case. So that is why that motion was dismissed. Um, Furthermore, what he fails to realize is that that was an advantage for him as far as them leaving the recording going. It would protect him in the event that there was any type of misconduct pertaining to the detective, such as if they continue to question him about the case or, they ignored his basic human rights, such as allowing him to go to the bathroom, get something to eat, get something to drink, things of that nature, or if they did not Mirandize him, or if they were coercing him into a confession or things of that nature. So him leaving that recording on was protocol for protecting both parties at this time. And so again, Zarel is just trying to find a loophole and is very unsuccessful at this time. Everything so far has been followed per protocol. Um, and so again, this is something that would potentially help him because it shows that he did tell them that he didn't want to talk and they stopped talking. So where we going, Zarel? Let's go. Where we going?
Even once a detainee has invoked their right to silence, you still continue to record. Is that a standard practice of your agency?
Yes, it is, for as long as they remain in the room.
And so when did you start recording?
Are you talking at Waukesha Memorial Hospital?
Correct.
Prior to you entering the room.
So you started recording before the detainee entered the room, and you said you keep the recording on until they leave the room. So would it be fair to say that there should only be recording while the detainee is in the room?
What difference does it make?
No.
And you did say for the record that that's standard procedure in your agency.
In regards to the interview rooms at our normal police department, which wasn't available at that time. Yes.
Would it be fair to say that you were not at the normal police department?
Don't matter.
Yes. However, with the audio, I was still trying to make sure I followed the policy to the best of my ability.
Can you show proof of that policy?
I don't have it.
So it'd be fair to say that there's no way to determine if that truly is policy if it can't be proven.
Objection.
Grounds.
Sustained. As to the form of the question, it's argumentative.
How can that policy be proven?
Objection.
Grounds.
Sustained on relevance grounds.
Do you know where that procedure is located in your agency rules?
Objection.
Grounds.
Relevance.
Sustained.
Grounds for the sustain, Your Honor.
Relevance grounds. Relevance.
It's irrelevant. Furthermore, that is something that you could have asked to be a part of your discovery. period. It's research that you can do. Anybody can look up police protocol and procedure. You should have had that paperwork so that you can use that as a reference to check off while Detective Carpenter is on the stand. It is not his responsibility to bring in any paperwork to confirm with you whether or not he followed protocol. He is not on trial here. That's what you're not understanding. I understand that the defense has to defend, and I understand that he feels that that's what he's doing. He's defending this third party intervener and trying to find a loophole. That is what any defense attorney would do. Okay, I get that. But that's not going to work because he followed everything to the best of his ability, given the circumstance. So, no, that ain't going to work, sir. It's irrelevant.
Not relevant. Next question.
It's not relevant.
No, keep going. We can take it up later outside the presence of the jury at our afternoon break, but for now, keep going.
I follow, Your Honor. I apologize.
Mhm.
Keep going. Good.
So once the detainee was taken to the Muskego Police Department, that would be a pretty standard police department. Would that be fair to say?
Yes.
And a second interrogation also took place at that police department, correct?
Yes.
Any reason why the first interrogation couldn't take place at the same police department that the second one took place at?
Well, the first interrogation again wasn't at a police department. Muskego was utilized as they had a lockup facility. So we interviewed you there.
Around what time was the detainee taken to the Muskego Police Department?
I don't recall the exact time.
And you also stated that another law enforcement officer.
I apologize for the interruption, but I just want to make sure my jury is in good shape. If you want to just take a moment to stand, it's a little slow, I think, for them. So we're just going to stand for a minute. Again, my apologies for the interruption. Anyone on my jury need a break? Are we good? I'd like to keep going. Anyone? Okay. No response to that. They said they're good. All right, we'll sit back down. And again, my apologies, Mr. Brooks. Hopefully you know where you were.
Yeah. It was another law enforcement officer who actually did the transport of the detainee at that time, correct?
Yes.
And you stated earlier in testimony that you and your partner followed behind that transport. Is that fair to say?
Yes.
And I'm assuming at some point that you will actually strike that. You stated to being present during the booking process into the Muskego Police Department. Is that fair to say?
Yes.
So why couldn't interrogation be conducted at that time, which would have been more ideal considering that you said there was a lockup. I forgot how you referred to it, but basically like a room that the detainee could be secured.
Well, you had been talking about at that point when we arrived at the facility with you that you hadn't eaten all day, you hadn't slept, so we wanted to give you an opportunity to eat, sleep, clear your mind, and refresh yourself.
And what bearing would that have on interrogation?
Well, I mean, you said you hadn't eaten, you hadn't slept. So I think a person is more focused when they're fed and they're rested. So we wanted to give you the opportunity to do that.
In your opinion, how would that have affected interrogation?
He just
Well,
told
I'm gonna
you.
excuse the jury right now, so if our jury, we could stand for the jury so I can take up a legal issue, please. All rise. All right, thank you. Be seated. So I'm going to take up two issues right now. One is when I paused earlier and told Mr. Brooks I would allow him to, it was regarding the policies. I want to know, as the proponent of the evidence, why you think that's relevant. And then secondly, the questions I believe that you are asking related to the interrogation, unless you can convince me otherwise, go to a legal issue that this court has already determined. But I'll hear you out on that. I didn't want to make an assumption, but I also didn't want to have you question this witness about what really are legal issues that this court previously addressed regarding the admissibility of the interviews.
Well, to the first one, about the policies, that's relevant because I think it should be stated for the record why he left his phone recording after he acknowledged that the Fifth Amendment right to silence had been invoked. At that point, interrogation is supposed to stop completely.
Well, I understand what you're saying from a legal perspective, but that doesn't mean the recording had to stop in and of itself at that point. He did
Right.
provide an explanation on the record.
His explanation was that it's policy, right?
He answered the question, why do you believe having the specific policy and him testify about the specific policy is relevant to his testimony?
Well, I believe that if that's in fact policy, it should be proven. It should be proven that that's a fact, that is a real policy. For all we know, he could just be saying that it's a policy.
What difference does it
And
make?
at that point, it makes him continuing to record after the Fifth Amendment had been invoked.
Well, right now, you assume facts that are not in evidence, sir. So you're the proponent of this testimony through your cross-examination.
Right.
And so without something more, sir, I don't see where there's relevance as to what the specific policy is.
Can you see what I'm getting at, though, Your Honor? If he's saying that this is a policy of his agency, he should be able to prove that that's policy. Because at that point, if there's no way to know that that is the correct procedure that they use every time, then
You're,
why?
again, making a lot of generalizations that I don't think are accurate as to what he said. This is a trial, sir, where the allegations in this case are that you drove through the Christmas parade, right, and caused death and injury to a number of individuals. There's also those other charges related to the bail jumping, the battery, and frankly, his conduct isn't on trial. We're not here about a police misconduct trial.
Exactly.
I'm not saying that some of this information might not be relevant to his credibility, things of that nature, but you have to, again, you're the proponent of this.
So basically what she's telling him is, let's just say that Darrell told him, I don't want to speak with you without an attorney. I don't want to speak, anymore at all. And they continue to record without his knowledge. And, they still went on to pressure him for a confession or, intimidated him or things of that nature. That would be a civil rights issue. And so what he would do is, excuse me, of course, file a claim, get us hire a civil rights attorney and say that his rights were violated during an interview where he was detained and receiving medical treatment. He was experiencing a great deal of pain. He was uncomfortable. He was scared, whatever he can come up with, right? And say that, they came in my room with the FBI, they lied to me or whatever. They tried to pressure me to give them information, although I told them that I was not willing to provide any further statements, and they continued to record me, they continued to talk to me. He would say all of that and see if he has a claim. And then that's when that attorney can go and subpoena police, the police handbook and see if any laws were broken, if any of Darrell's rights were violated per police protocol, and see if he has a case. This is not the time to do that. All right. Now you asked him why he continued to record you and he gave you an answer. What you're upset about is the fact that you told them that you didn't wanna answer any questions, you didn't wanna talk anymore, but when he left the room, you did continue to run your mouth and proclaim your innocence, and you didn't realize that that was being recorded. That's not his problem. He's doing his job, all right? And furthermore, like I told y'all, during a preliminary hearing, there was a motion to suppress this particular part of the first interview/interrogation, and, I think Judge Doro dismissed that altogether, and that's why it was admissible in court, and they played it, and that's the end of it. Like, you're not gonna get anywhere with this. Again, I said it already a couple of times. Detective Carpenter is not on trial, and so you can't sit here and question if he did this wrong, that wrong, or the like. It doesn't matter.
Why do you believe those policies relate to an issue of fact in this case or otherwise go to your defense?
I believe that is relevant because it can show that at the very minimum, that first interrogation and anything related to it should not be admissible as evidence.
That's a legal determination that I've already raised. Your attorneys represented you at that time. They made
Mhm.
a variety of arguments. So to then make this trial about that interrogation, it's not relevant.
I'm
Right.
not making the whole trial of it.
But the issues are legal issues that this jury will not be asked to answer. I've already ruled on the admissibility. That's a legal determination. So I'm not seeing the relevance to those specific policies, and there is simply no requirement that the state or this witness has to prove those policies. You are representing yourself. Hold on, let me finish. You're representing yourself. I'm not aware of any subpoena that required him to bring those policies with.
Mhm.
So that would have been on you if you felt it important to cross-examine him on those policies to
Mhm.
require that. I'm not aware of that. Have you done that?
Nope.
Obviously, it was going to come up.
Did you
No.
issue a subpoena ducus tecum to this witness to bring with any of his policies
How
related
can
to
I do that
interrogation?
myself, Your Honor? How can I do that from a jail cell?
You
You were
should have
given
thought
all.
about that when you decided to fire your attorneys. That is not their fault. I am sick of you. Nobody's gonna hold your hand and help you do any of this. You shouldn't have brought it up. Just let it go. Just let it go. You didn't subpoena any type of police protocol documentation. You could have had, um the police chief as maybe a witness if you just absolutely had to question proper procedure and protocol and policy, but you didn't. And so we're not going to waste any time on this. This is not a defense for you. He didn't do anything wrong. Furthermore, even if he did, it's not a criminal issue. That is not what this trial is for. That would be a civil rights issue. Now you can call your mama and ask her to send you incriminating evidence against Erica, okay? You can call whoever you calling is feeding you all this 5 sit stuff. but you can't figure out how to subpoena documents? No. Let it go.
All of those blank subpoena copies, sir, and you could have filled that out in a way for this witness to require. You didn't do that.
So who would have served him?
The state would have. They served your other subpoenas. But be that as it may, that's not what we have here.
Mhm.
So I believe that your line of questioning is on a topic that's not relevant to the issues in this case. And so I'll give you one more opportunity. Why do you believe that questioning him about the policies are relevant to your case?
It's relevant to the case because why would he be recording before people are even in the room and then after?
Well, that's argumentative, sir.
once
So
Mhm.
that's not a
Fifth
legal
Amendment,
basis.
once the Fifth Amendment is invoked, interrogation is supposed to stop. Period.
It
There's
did
supposed to be
stop.
no more recording, no more questions asked.
That's not what that says.
That should be the end of the whole interrogation.
Mm-mm.
These are legal issues that you're trying to raise before the jury. I've already dealt with the admissibility, so you've not provided a legal basis to further question this officer about policies related to the interrogation and the recording. He has answered questions. I gave you some leeway on that, and his
Mhm.
answers are before the jury. Certainly, you'll be able to argue the meaning of that or the lack thereof during your closing arguments if we get to that
Mhm.
point.
Mhm.
Let's move on, though, to this issue about why I excused the jury. And again, I believe you're questioning him about legal issues that aren't relevant, but you're the proponent. You want to question him. What's the legal basis you believe I should allow you to continue with that?
What legal basis are you referring to?
I believe you were attempting to elicit information or evidence, testimony from this witness on issues that are not relevant.
Is that referring to the same question
Not
I
the
asked about the
policies, what I
policies?
just stopped the testimony for, because I don't want to create issues in front of this jury related to legal issues that are not before them to determine.
And is that referring to the question about the policies?
No. You were asking him, why did you stop? Why did you not question him further? Meaning, why did this detective not question you when you got to the Muskego Police Department? Why did they wait till the next day? I stopped because I know the law on this area, and I know that when a subject invokes their Fifth Amendment, or when you're a defendant in state, it's the 14th Amendment, but nonetheless, right? You have rights under the Wisconsin Constitution as well, but that because you only invoked your right to remain silent, they waited to question you until a sufficient amount of time had passed, in addition to the other reasons.
Yes.
I'm not going to let you question him in front of the jury about that specific thing. Or at least I'm cautioning you that I'm stopping it because I don't see where that's relevant. But if you keep pressing him on that, you're going to open up the door to him saying, because I was following the constitutional requirements and giving you a break in the questioning so that I could, get a statement I believe would be admissible later on. That's what I'm trying to avoid.
With all respect, Your Honor, I don't think he would have said that.
How do you know?
My concern was we were headed down that path. So if there's some
ain't
other
smart enough.
reason you
The
want to
14th
question
Amendment
him,
would have been referring to the having the attorney present.
I'm sorry, say that again.
So you said when you stated that you know the law in that area about the Fifth Amendment and the 14th Amendment.
Mhm.
What were you referring to on the 14th Amendment?
I'm not going to explain that any further, sir.
Self-incrimination.
Let me just ask the state if they see this any other way. If you think I'm mistaken, and I was concerned we were headed down that path, which would be a legal determination. But if there's something the state sees that differently, please let me know.
I actually thought that Mr. Brooks was questioning this witness about why they didn't do the first interrogation at Muskego. So I thought that there was some miscommunication between the two of them. And I just wasn't sure. I didn't want to object for that reason because I just wasn't sure what Mr. Brooks was talking about at that time.
Well,
And
that's fair enough, because if that's what you were trying to question
I
him on,
agree.
then I think that's fair game.
I
But
agree with Attorney
might have
Daisy.
Okay. So they're going back and forth about the Fifth Amendment. We all know the Fifth Amendment is the laws that protect you against self incrimination, the right to remain silent, and the right to have an attorney present, right? So Darrell was Mirandized and he agreed to answer questions, right? However, midway through, he decided that he did not want to answer any more questions. And basically, he feels that since he said that, that was the end of it. But what, like I said, what he didn't realize is that per police protocol, they can still record you until you left, or I'm sorry, escorted out of the room and placed either in a holding cell or wherever they choose to take you back home or whatever the case may be. At the time, he didn't know that he was still being recorded. And so his previous attorneys brought that up, basically saying that the information as a role provided after he invoked his Fifth Amendment right should be inadmissible in court. Now, I have to go back and do some more research because I can't remember if they played that portion um at the trial or not. However, I know I did do a video about it. So I have to check my facts regarding if it was admissible or not. However, basically what Judge Doro is telling him is that he invoked his um Fifth Amendment right that night. They have to wait a certain amount of time to go back and try to interrogate. Okay. And that is what they did. The Fifth Amendment does not prevent statements made after a period of silence. Okay. So they have every right to stop the interrogation, hold you for a little while, like you said, let you get your thoughts together, make your phone call, whatever the case may be. They can try to interrogate you again. At that time, if you still feel like I don't want to talk, then you ask for a lawyer, or either you're going to waive your rights and they're going to interrogate you, which in this case, he waived his rights, and that's when they did that 4 hour long interrogation. And so now he's becoming upset because he doesn't understand the law. He's trying to interpret it the way he wants to interpret the law and not listening and trying to challenge them when it's plain as day what they're telling you. You ask them to stop asking you questions. Okay. Now let's just say that he asked them to stop asking him questions. He didn't want to answer questions, but then he waited a couple of minutes and he decided that, he wanted to participate in the interrogation. They would have to come back in the room and Mirandize him again and inform him that they are going to be questioning him, make sure he understands his constitutional right to stop the interrogation at any time, to ask for a lawyer at any time, whatever the case may be. All right. He did not do that. You waited till Detective Carpenter left for whatever reason, because I guess you felt that you were cooler with Detective Stern or whatever, and you decided to talk to him, I guess, to see what information he could give you. But by law, he cannot give you anything else. He cannot question you because you decided to invoke your Fifth Amendment right, the right to remain silent, meaning that they can't ask you any more questions about the case. If you choose to talk, that is on you, but I can't ask you anything. So it doesn't matter whatever police protocol he's trying to say that they violated, or, whatever. It doesn't matter. It doesn't matter. It doesn't matter.
Interpreting
That's
it
what I was
differently.
getting at. I didn't mean to cut you off,
Go
but I
ahead, go
agree
ahead.
with Attorney Bailey. That's exactly what I was getting at.
All right, well, you understand it's my job to protect the record too. So I want to make sure that, all right, so with that understanding that you are questioning this witness about why they didn't take you to Muskego for the first interview, is that where you're wanting to go with all of this?
That was the question.
All right, well, I might have misunderstood, but in any event, it gave us an opportunity to talk about the other thing, so that's okay.
So is that a fair question to ask then? Because I'm confused now if I'm even allowed to ask that question.
I think part of the issue sometimes, sir, is there's either, sometimes the questions aren't as artfully worded as they could be. I know you're doing your best. I like to look at it this way. Questions that are a sentence at a time, meaning a thought at a time, because then they're not compound, are the easiest for a witness to answer. And when you start bringing in other things, it can be confusing, and then I might not understand, or a party or a witness might not understand what you're asking. So looks like it's one of those situations where I was a bit unclear. It's been clarified. If that's the line of questioning that you are going to go, then that's fine. Then I would allow that. I'm not going to stand in the way of that. If the state objects, I'll obviously, that's a different story. Then I'll have to rule on it. But I think we're all on the same page now.
And just for the record, Jared, I will be objecting. I don't want there to be, just because I think this has been asked and answered. He was taken to Waukesha Memorial Hospital for medical clearance. They want to minimize the number of times that he's transported, and they needed the information sooner rather than later. So I will be objecting as to asked and answered. I just didn't want to, we asked the question that the court suggests, and then I object, and so I do want to put that on the record just so the court's prepared for it.
Understood.
The question of why wasn't the first interview conducted at Muskego Police Department had not been answered.
I'm going to let you ask that question. So even if they object, we'll put everyone on notice. So because I think it's reworded a bit differently. So I think it's fair. I'm going to let you ask that. All right. Let's bring the jury back out. I might have to get me more water too. Thank you so much. You have enough water, sir? You have water?
Yeah.
You have enough?
Run through this one.
All right, we'll make sure there's another one. All right, I can't see behind the monitor. What you got or don't have.
Thank you.
Mm-hmm. All right, thank you, everyone. Please be seated, and Mr. Brooks, you may continue with your questioning of this witness.
And do you recall why the first interview was not conducted at Muskego Police Department?
Yeah, so in regards to the first interview at that point, as I kind of stated in my earlier testimony, we didn't know exactly where you'd end up. Muskego didn't become an option and something we thought of as a final place for you until after the first interrogation was attempted and was over with.
And do you recall if you made that determination yourself, or was it your supervisor or something of that nature?
Objection relevance.
Ground.
As to where they were going to take you?
Yes.
Overruled. The witness may answer.
I discussed it with Detective Casey.
Mm-mm.
And at that time, that's when you learned that Muskego police station was a viable location.
Yes, that's the point at which we made the decision.
Had you ever used that police station before in any of your investigations before that evening?
Objection relevance.
Grounds.
Overruled. The witness may answer.
I had not. But when our department first closed, that was given as an option for us, being we didn't have our own municipal lockup.
And do you recall around what time you started to conduct the second interrogation?
Yes, 12:11 p.m. on the 22nd.
And do you recall how that interrogation started?
Yes, I explained to you I had more information about the domestic, and that's what I was looking to speak to you about.
Do you recall making a statement that we all know how women can be? They're crazy.
I do.
And what did you mean by that?
It was just additional rapport building that I've talked about in my earlier testimony. Speaking to you on a person-to-person level, quite honestly, it wasn't a judgment I generalized towards all women in the world. It was just wanted you to feel comfortable talking to me as a person. I felt we had rapport. I felt I could tell the night before you were comfortable speaking to me. And it was just a continuation of that.
So it'd be fair to say that comment doesn't reflect your opinion of women.
Correct.
Why did you feel that would have been necessary to build a rapport that you stated that you already felt that you had?
Because it was just being relaxed. I was relaxed. I didn't want to make you feel unnecessarily nervous. We had been, talking to each other in the casual conversation from the night before, very civilly, very openly about non-custodial topics. And I was just continuing to go along those lines. It wasn't anything other than to just communicate with you on a stiff level, relaxed level.
And do you feel, would it be fair to say that other comments could have been used to keep the detainee at ease?
Objection, vague.
Grounds.
Sustained as to the form of the question.
Was there any other conversational tools you could have used to keep the detainee at ease?
Objection, same.
Grounds.
Overruled. The witness may answer.
Perhaps, maybe.
So it'd be fair to say for the situation, you felt that the conversational tool you use would be more appropriate at that time?
So just ask that one more time, please.
You felt that, would it be fair to say that you felt that at that time, the conversational tool that you use would be more appropriate for the situation?
I don't know that I was really thinking about appropriateness. Like I said, I was just conversing you on a normal person-to-person level was my intention at the time.
So it would be fair to say that you assumed that would put the detainee more at ease by starting the conversation with along those lines?
I wanted you to be relaxed. That's not anything that I did just specifically for you, Mr. Brooks. I always want people to be as relaxed as they can be. I want them to feel comfortable to talk to me if they are willing. It doesn't change the fact that ultimately I have to read Miranda. But I always want all the people I talk to feel comfortable and be willing and know that they can talk to me if they want to.
Speaking of Miranda, do you recall reading the Miranda rights in the second interrogation?
Yes, I do.
Do you recall how long into the interrogation before you read the Miranda rights?
Objection.
Grounds.
Objection, misstatement,
Grounds.
and mischaracterization of the evidence.
Grounds.
Well, sustained is to the form of the question.
It would be fair to say that the second interrogation was pretty long. Would that be fair to say?
Yes, sir.
Do you recall when in the second interrogation you read the Miranda rights?
Your Honor, I am going to object again to the form of the question.
Grounds.
The interrogation began, the court made a finding as to when the interrogation began prior.
I'm going to sustain the objection as to the form of the question.
I'm going to cut the video off here. Okay, so basically, he's trying to say that his rights were violated. What he doesn't understand is that the police does not have to Mirandize you until they start to question you about the matter at hand. When they originally brought him in to the room to be questioned further, they made sure that he had something to eat that night, that afternoon. They asked if he needed something to drink, if he needed to go to the bathroom, how he slept, what his pain level was. They made sure they like he said, made sure that he was comfortable enough to talk to them. He was in the right headspace to talk to them prior to being Mirandized and questioned. He knows very well he was Mirandized because you have to sign off on paper stating that you agree to be Mirandized and be questioned, and that if you want a lawyer, you can ask for one at any time. He's done this over and over. You're a career criminal. Okay. So we're going to stop it here. We are at 57 minutes. This cross examination is approximately 2 hours. So we will pick back up on another day. I hope you guys enjoyed my commentary. Leave me some comments, okay? Good or bad. And I will talk to y'all next time. All right. Y'all be easy. All right. Peace.